We're going to start with an overview of the Forstater judgment from Robin, and then each of us will give a brief comment on the judgment or its implications, something that has struck us particularly, and then we'll come to your questions. So just for people who are still coming in, this is the webinar about the Employment Appeal Tribunal's judgment in Forstater. I'm Katya Hosking, I'm chairing today's session. I've already said if you could put questions in the Q&A box, please, rather than the chat box. We will be answering questions towards the end. Our speakers today, I'm delighted to welcome Robin Moira White, who is a discrimination barrister practicing from Old Square Chambers. In 2011, she became the first barrister to transition in practice at the discrimination bar. She appears regularly for both employers and employees in cases with a transgender content, and she writes and lectures about the subject, which she's listed in Chambers and Partners as the go-to lawyer for trans matters. She and Nicola Newbergen have just published a practical guide to transgender law. And I should also say that a number of us at Devereux write for Bloomsbury's discrimination law textbook, and we're delighted that Robin is taking over the chapter on gender reassignment and trans equality. I'm also joined today by Vicky Wickremeratne. Vicky's a partner in the London employment practice at Allen and Overy. She developed her career in London and Hong Kong, and she's held senior roles both in-house and in private practice. She advises employers in managing complex people risk, and her contentious work focuses especially on whistleblowing and discrimination claims. She's a long-standing and very active LGBTQ+ ally. So just to flag up again the note that given today's topic, we are going to have to talk about and refer to language which some people find uncomfortable or distressing. So I want to make sure people are aware of that, although obviously we intend that it won't be gratuitous. So I hope that we have most of our participants in the webinar now. So I'm going to hand over to Robin first to introduce the judgment. Robin.
Katya, thank you very much. Right, this is going to be a bit of a canter through what were long judgments, both in the ET and especially at the EAT. So there will be an element of abbreviation and therefore simplification in a case which is not simple in some respects. So for those of you who've been stowed away on the International Space Station for the last couple of years, Maya Forstater worked as a consultant for an international development charity called the Centre for Global Development, and they have a presence both in the UK and elsewhere around the world. Ms. Forstater has very firm views about trans matters. She believes that trans women are men, that sex is immutable, and that trans women should not have access to a number of female spaces. And she was not backward in letting people know her views, and other employees or consultants at CGD came to know about that and brought that to the employer's attention. The employer interviewed Ms. Forstater and came to a view that her consultancy contract should not be renewed. And she was unhappy about that and brought a claim in the Employment Tribunal alleging that she had been discriminated against on the basis of a belief and beliefs that, amongst other things, as I've said, sex is immutable, and that gender identity is not a significant matter. There's a background of cases about religion and belief, particularly, and as related to the workplace. And I know that Katya later on is going to talk a bit about a case called Ngoli, so I won't go there directly. But more closely relevant, there have been a couple of cases recently in the run-up to Taylor. One was a case called Higgs and Farmers School, where a school assistant with strong religious beliefs had beliefs very similar to Ms. Forstater, but was clear that her beliefs would not be expressed in the workplace. And the Bristol Tribunal last autumn decided that her beliefs were protected. So in some ways, the EAT judgment in Ms. Forstater's case isn't that unusual in one way. We'll come to how it is. But that Ms. Higgs was very clear that she would not express her views in the workplace or in the school. Equally, there was a case called Wickremeratne, and Dr. Wickremeratne assessed people for disability benefits. He was very clear, based on his religious beliefs, that he would not respect the pronouns or identity of people who came in front of him. And if he perceived that the person was male, he would address them as male. And the Department for Work and Pensions dismissed him for that. And that dismissal was upheld. He, in fact, is appealing. That appeal is to be heard in the autumn. So that'll be interesting to hear. Now, Ms. Forstater found herself in front of Judge Taylor in the Employment Tribunal, only dealing with a preliminary issue as to whether her belief was a protected belief. So the case didn't deal with manifestation, and some of the other learning is about cases where people have manifested beliefs in the workplace. Ms. Forstater's case, to some extent, her desire, because both the employer and the judge were suggesting that it was sometimes difficult to separate manifestation and belief, and suggested that it wasn't necessarily the easiest thing to do to just deal with belief, but it was more Ms. Forstater's desire that it go ahead in that way. He listened to her evidence and the statements that she'd made, that she would respect other people's pronouns and description of themselves. But after the cross-examination that he heard, he came to a rather different view. He formed the view that she would misgender people when she felt that it was the right thing to do. Now, that would include, one assumes, circumstances where, for example, a trans person was using the facilities at work appropriate to their affirmed gender, which she might object to. And or she might object if a customer, for example, of the client was behaving in that way. And Judge Taylor held, because of the absolute nature of her beliefs, and what I have described, it's not the judge's word, I've described as a sort of self-granted wayleave to misgender, then her beliefs failed the legal test to say established in the case of Nicholson and Granger. And there are a series of tests to see whether a belief is protected. In particular, Judge Taylor found that her belief failed what's known as Granger 5, which is the last stage of the test, as to whether it's a belief that should be supported in a liberal Western democracy. The guidance on religion and belief suggests things like membership of the Ku Klux Klan, for example, would not be protected. But it was, I think, Judge Taylor was influenced by the fact that she would, it was part of her belief that she would express matters in the workplace when she felt she wanted to. So having failed, having lost in terms of whether she had a protected belief, of course, that ended her case, because if there was no protected belief, there was nothing to protect. She obviously was unhappy with that judgment and appealed to the Employment Appeal Tribunal, and recognising, I guess, the importance of the case, it came in front of the present president of the EAT, Judge Choudhury. And that case was heard back in April. over a couple of days. And by this time, both parties had been represented by junior counsel in front of Judge Taylor. Ms. Forstater had taken in silk, and there was also two interveners. The Equality and Human Rights Commission intervened, and also an organisation called Index on Censorship intervened. And they are very, Index on Censorship believe in pretty much unrestricted free speech. So they believe that any restriction on speech is inappropriate. Now, there are some odd features of the judgment. There was no appeal on the facts of Forstater. However, what Judge Choudhury decided was that Ms. Forstater had given evidence, in fact, she'd given a witness statement that said she would respect other people's identity and she would attempt not to misgender or dead name them. Now, Judge Taylor had found that that wasn't so, that she would do that, but the EAT found that he was wrong to have found that, and have predicated their beliefs, predicated their judgment on the fact that she would stay within those boundaries. Now, that is maybe an issue when we come to appeal, because that it doesn't look very much like the judgment that there was. The EAT heard a lot of argument about the Convention on Human Rights, Articles 9, Articles 10, which had been argued below, and particularly Article 17, which hadn't been argued very strongly below. And they, we could spend a couple of hours picking through that jurisdiction, but we won't, because we need to look at the consequences, I suspect, more closely than the particular judgment. But there certainly seemed to me to be some non sequiturs in the way in which the human rights, the Convention on Human Rights has been used. And Judge Choudhury's view was that Granger 5 was really quite limited in extent. And so only beliefs like Nazism and totalitarianism actually fail, in his view, Granger 5. And so her belief was a protected belief, and the case therefore has been remitted to a fresh tribunal for rehearing. But it's quite an extraordinary judgment, because I think the EAT recognised, with the publicity that surrounded it, Ms. Forstater was crowdfunded. There's been a lot of comments since about people with gender critical views being empowered and enlivened by the judgment. And the judgment sets out very clearly, twice and at length in the judgment, that the judgment is not wayleave for people to be discriminated or harassed, discriminated against or harassed in the workplace. And of course, harassment is creating a hostile, degrading, humiliating or offensive environment. So, for example, expressing the view clearly in the workplace that trans women are men and shouldn't be using the toilet facilities, for example, in the workplace associated with them, would be highly likely to fail that test and to be unlawful harassment. And the tribunal, Judge Choudhury plainly had in mind that there was a risk that their judgment was going to take people into that territory. I can't recall seeing a judgment with a warning like that in quite that way. Katya and Vicky, I think that's a good trundle through the facts and where we've got to by the end of the judgment. I think, Katya, back to you, I think, for the next segment.
And I'll successfully remember to unmute myself before I start speaking. I'll pat myself on the back for that. Yes, the case that I think it's interesting to look at, and I'm just going to put the case reference in the chat box. I can't promise we'll do that for every case that we refer to, but I've got it there for this one. So oh, Robin hasn't unmuted herself.
If anybody's struggling, there's an excellent recent publication that has a lot of these references close to the last plug you're going to get today. Right.
So the Forstater case, I mean, as we know, it was a decision it was a preliminary decision on a preliminary issue, but the case itself arose from a complaint that had been made about Maya Forstater's gender critical social media posts. So one question that employers have to wrestle with is how they can appropriately uphold employees' freedom of expression and avoid religion or belief discrimination, while also trying to manage social media posts which might conflict with an employer's legitimate aims. And I think in that context, there are useful lessons from the Court of Appeal case of Ngoli and the University of Sheffield. So Felix Ngoli was a social work student. He was on an accredited postgraduate course, which, once he completed it, he'd be able to register as a social worker and practice in that profession. Mr. Ngoli is also a devout Christian who takes the Bible to be the full and authoritative word of God, and he relies on it in his daily life. He posted, while he was on the course, about 20 comments on an American news website condemning same-sex relationships on religious grounds. And they were posted from his personal Facebook account, so they could be linked back to him. He was identifiable from those comments. And the comments, some were biblical quotes, some used biblical language, and then some had observations of expressing his own views. And just as an example, they included the comment, if a man lies with a male as with a woman, both of them have committed an abomination, from Leviticus. And he also said, homosexuality is a sin, no matter how you want to dress it up. Now, the university received a complaint about these posts from another student on the same course. And following an investigation and a meeting of the faculty's Fitness to Practice Committee, he was excluded from that accredited course, although he was offered the opportunity to finish an alternative course, but one which wouldn't lead to the professional qualification. So he brought a judicial review claim on the basis that the university's decision was an unlawful interference with his Article 9 and 10 rights. The High Court dismissed his challenge. It said that the nature of the posts alone wouldn't have justified removal from the course, but it accepted the university's submission that Mr. Ngoli showed a serious lack of insight into the potential impact of his posts on service users, and that Mr. Ngoli's position appeared to be entrenched. On that basis, the High Court found that no less intrusive measure than excluding him from the course could have been used, so dismissed his challenge. The Court of Appeal agreed with the university that it was a legitimate aim to seek to maintain confidence in the social work profession. It found that regulation of the profession could legitimately seek to ensure that reasonable service users of all kinds perceive they will be treated with dignity and without discrimination. So there was a recognition that in the context of social work, where there are vulnerable service users who, when they come into contact with the social work profession, won't be able to choose who they are assigned, but it's a legitimate aim to make sure that those people perceive that they will be treated without discrimination. So the Court of Appeal agreed that Mr. Ngoli had an obligation not to allow his views about a person's lifestyle to prejudice his interactions with service users by creating the impression that he would discriminate against them. So it's important to say there was no dispute, there was no evidence he'd ever discriminated. He had worked with same-sex couples already in placements. There was no suggestion that he said or done anything inappropriate in that context, and he was quite clear that he would not discriminate. So this was about an obligation on him to think about the impression that would be created. But the Court of Appeal found that the university's internal proceedings against Mr. Ngoli were flawed and unfair. And in those circumstances, the university's decision to exclude him was disproportionate. Now, I think that the case is helpful to look at because the judgment focuses on justification and on proportionality in particular, which are also relevant in the context of discrimination cases brought under the Equality Act. It's also interesting that the case effectively sidestepped the entire issue that's addressed in Forstater that was decided one way in the Employment Tribunal and has now been reversed in the Employment Appeal Tribunal, because it was treated as an Article 10 case. It was a freedom of expression case. And so there was no question that this was an interference with his freedom of expression. Everything turned on justification. So what I think is interesting is that the case effectively involved important public values which appeared to come into conflict. And in the end, it turned on the question whether each side had done enough to resolve those tensions. So the High Court held that Mr. Ngoli hadn't done enough to show that he understood the impact his posts might have on vulnerable members of the public. But the Court of Appeal disagreed, and it found that actually, if Mr. Ngoli had become entrenched, it was as a result of the university's stance. In particular, the university told Mr. Ngoli at an early stage that he could never express disapproval of homosexuality in a public forum. So no matter what language he used, no matter how mildly it was framed, and no matter the context. And as the Court of Appeal pointed out, that wasn't actually consistent with the professional standards or the professional guidance. So it was unsurprising that Mr. Ngoli reacted so strongly. So I think it's a helpful judgment to read because it really conveys how quickly the positions, in this case of the university and the student, but the same is true of employers and employees, how quickly people can be pushed into a more extreme position because of an issue like this arising. So from the employer's point of view, it's sensible to think about a couple of things. So where freedom of expression is an issue, which it will be in anything to do with social media, a blanket ban on expressing opinions on social media won't be lawful. When employees engage in social media, they will always have to exercise judgment, both as to the extent which they can be linked with the employer and on the nature of the posts they make. So it's especially important to provide examples of what's likely to be acceptable and what isn't, because in the end, it's the employees who will have to exercise that judgment. Another thing that came up in the Ngoli judgment was that Mr. Ngoli obviously thought he'd used quite moderate language, and the university thought that the sort of terminology, the biblical terminology like wicked and abomination, was quite extreme. But there'd never been an attempt to explain to Mr. Ngoli that actually those terms, those biblical terms, when they weren't being used in a theological context, could be understood as intrusive and offensive. So there'd been no dialogue between them about what it was that was problematic. So in taking that into account, really, the sort of procedures, the investigations and disciplinary procedures should be operated as far as possible in a way which avoids entrenching positions at an early stage, because the clear steer from the court is that there is nuance here, and a sort of firm stance and an immovable and absolute stances on either side is not going to be helpful. And finally, decisions about imposing sanctions will need to take into account the importance of freedom of expression in a democratic society and respect for religion or belief, as well as the nature of the employer's business and relevant professional regulations. So I think it's certainly a case that's worth looking at. Both the High Court judgment and the Court of Appeal judgment repay study. So that's my reflection on the judgment. And Vicky, I think you had some more practical implications.
Thanks, Katya. So you asked me to reflect on the practical takeaways for employers arising out of this judgment. And I was thinking about this and I was thinking, you know, as a starting point, most employers don't want to take a position on beliefs that may set people apart. I think that's just most people's starting point, and that applies whether we're talking about beliefs around gender identity, anti-vaccination, Brexit, whatever, because most employers are focused on maintaining a positive culture where employees can work productively and safely and with dignity and respect. I think it's also interesting that in recent years, many employers have been focused on empowering their employees to bring their whole selves to work. And of course, in doing that, that might include employees bringing their beliefs to work. And I think this judgment acknowledges that certain beliefs, even if they are potentially offensive, are capable of protection. But of course, I think what we've all established, you know, here is that that doesn't mean people get to manifest that belief in a way that harasses or discriminates against others. And employers will be potentially liable if they do. So I think from a practical perspective, my view is that the judgment, and Robin and Katya, you can disagree with me if you like, but I don't think it necessarily changes where we are or where we were, but I do think it's a sharp reminder of the potential for conflict in the workplace, and that this needs to be anticipated and it needs to be managed proactively. So what does that mean in practice? I've seen, you know, some commentators suggest that, you know, all controversial discussions should be prohibited in the workplace, but I'm not sure I think that's the answer. I don't think it's, my own view is that I don't think it's realistic to think that discussions on different viewpoints can necessarily be suppressed, or even that that's necessarily a healthy thing to do in a culture where you're trying to encourage diversity and inclusion and different perspectives, which, you know, many employers are. I think it's also potentially concerning in terms of the potential for inhibiting speak up. I also think that, you know, understanding different perspectives is an important pillar of building empathy and ensuring a respectful workplace, and is consistent with all the goals that employers have when they're trying to work on their diversity and inclusion. I mean, if we think of some of the difficult and sometimes painful discussions that have been facilitated in workplace, you know, in the last 12 months following, you know, the events in the US last year around race, you know, it is possible, I think, for difficult things to be discussed in a way that is managed safely and doesn't transgress people's dignity in the workplace. So I think employers need to help employees understand that it's how they manifest their views at work that can, you know, be a positive thing or potentially a damaging thing for workplace relations. And there are a number of different pillars, I think, you know, that employers need to focus on. So I suppose the obvious starting point is to be looking at your workplace policies. And, you know, in that I have in mind in particular your dignity at work, anti-harassment, bullying, and your diversity and inclusion policies. I mean, I think most employers' policies will make clear that, you know, not only are employees required to treat everyone at work with equality and fairness, but they have to promote a positive and harmonious environment. And I quite like the idea of making it a clear responsibility on workers to ensure that they navigate, you know, their expression of views, if they're going to be expressing their views with colleagues, that they do so in a respectful way. I think social media policies are particularly tricky, and it's really interesting, Katya, to hear what you had to say about that particular case in terms of the difficulties of imposing a complete ban. You know, how far can employers go in regulating, you know, what you put on your social media account? You know, public posts, you know, even done in your personal capacity, can be linked to your employer potentially, and potentially bring your employer into disrepute. And I think we've seen from the cases, you know, Higgs and Farmer School is a good example, that discussion doesn't have to be on a professional, you know, social networking platform for it to be potentially problematic for your employer. Instagram, Facebook, all of it is potentially up for grabs. So I think, you know, I think what we're learning from this case is that, you know, posts that can give rise to legitimate concerns as to how a belief might be manifested in the workplace, you know, need to be sort of scrutinised by employers, and the consequences of those posts considered quite carefully. I mean, I think, Katya, the point that you make about not taking steps to entrench positions early is important. I think sometimes there might be a bit of a tendency to have a knee-jerk reaction and want to be seen to be taking some action. But I think what we're learning is that there needs to be a sort of step back and look at exactly what this is. Is this a particular belief, and is that belief being manifested in a way that is potentially or actually problematic? I think practically we can encourage employees to think about their privacy settings, and to avoid posting material that could be offensive or potentially damaging to an employer's reputation or their professional reputation. And some policies we see, you know, go as far as encouraging people to exercise caution when commenting on sensitive subjects such as religion or politics. But I appreciate that employers need to think very carefully about, you know, the extent to which they can sort of temper or fetter their employees' freedom of expression. Dress and appearance policy, I think, is one worth looking at. You know, does it make clear your organisation wants to ensure that, you know, everybody's needs are respected, everybody from all different cultures and religions, as well as supporting trans and non-binary staff to dress in the way that they feel comfortable and in line with their gender identity and expression. I think that might include a requirement that clothing in the workplace shouldn't carry wording, pictures or emblems that might be potentially offensive or confrontational. An example I can think of might be some of the T-shirts with slogans that we've come to see sported in the gender identity and trans discussions across the spectrum. You know, wearing clothing of this nature in the workplace might be reasonably expected to cause offence in a workplace, if indeed T-shirts were considered professional attire for any given workplace. But all of these policies are kind of only as good as the extent to which you bring them to life. So I think employers do have to work quite hard on their workplace training and how they facilitate discussion around these issues in the workplace. I was talking to somebody from the LGBT community who's just starting out in their career, and they had expressed out to me about how these sorts of policies are disseminated in large organisations. I think they can be sort of buried on the intranet. And so thinking about how they're brought to life through training, and perhaps you know, how they can inform wider conversations around values in the workplace, particularly around you know, respect at work. Case study training, I think in practice we find, is particularly impactful, because I think it's helpful for people to understand the different spectrum of views that their peers and colleagues might have around the same fact pattern. And it's often quite effective to leverage examples of detriments that have been cited in particular cases. So for example, if we were looking at, I don't know, a case study around trans discrimination, we might leverage, Robin, some of the detriments that were cited in the Jaguar Land Rover case to sort of debate, you know, whether any particular position is offensive, and indeed whether, you know, in any of the statements that were made in that case, whether they might have indicated an individual's belief, and is that a belief that's capable of protection. Finally, effective communication channels. I think it's really important for employers to ensure that they really do have a means of ensuring that issues or potential conflicts arising out of different beliefs or different positions in the workplace have a means of sort of being escalated in a safe space. You know, if somebody is uncomfortable sharing a single sex facility with a gender fluid colleague, you know, they need somebody to be able to go and talk to privately about that in order to air their concerns and figure out a solution. I think that what we are seeing from some of the recent open letters posted on the intranet from employees, tells us that if we don't find a means of channeling these things internally, there's every likelihood that we will see it sort of aired, more broadly on the internet in due course. So I think this is of particular importance to employers. But with all of that, I suspect I've taken up my 5 minutes. So I'll leave it there and hand back to you.
Yeah, I've been asked to express a view. One never criticises a solicitor for having the longest 5 minutes in the world, because I would never do that. I've been asked to express a view or two about whether the judgment might be appealed, because one or two people are asking that, and I must make clear that I've absolutely no special knowledge. I am not instructed for any party in the case. So, but my reading of the timing is that the employer has until around about the end of June to make a decision as to whether to make an application to the Court of Appeal, because I understand the rather odd way in which the judgment was handed down by a deemed handing down at a particular time means that there won't be an application. There wasn't an application to the Employment Appeal Tribunal for appeal. So we won't know either until it's announced or into early July, I think, as to know whether it's appealed or not. Now, is the case appealable? I think plainly so on, I think, two grounds. One, that I think it's departed from the factual matrix found by the judge. And we've seen that over the years. I cut my Court of Appeal teeth in a case called Post Office and Foley about unfair dismissal, where the EAT had done exactly that. The EAT had a completely different view about things, substituted their view in the EAT, and the Court of Appeal turned around and said, no, that's the judge's job. And there is a view that that's what's happened in this case. The second area, and indeed this answers one of the questions that I see we've already had in the Q&A, is that the way in which the Human Rights Convention on Human Rights has been interpreted has effectively emasculated Granger 5, that to say the only beliefs that are not going to be protected are Nazism and totalitarianism is far stronger than the religion and belief provisions provide, so that it's forgotten things like dignity, which is in, for example, which is in the religion and belief regs. And there is, in my view, a very clear argument that perhaps dazzled by the panoply of legal talent in front of him, Judge Choudhury didn't perhaps step back a little, as Vicky's been talking about, and think a little bit about what reducing Granger 5 to Nazism and totalitarianism might mean, not just in this field, but in the field of other beliefs and other interactions in the workplace. So I think if it's to be appealed, I think those are the areas that might be looked at. Whether it's to be appealed, as I say, we'll wait and see over the next week or two. Katya, I think we've probably got a bit of time left for some questions.
We certainly do. So yes, and we've got quite a few questions coming in. I think one of the questions, I think this actually came in by email in advance, picks up on something, Vicky, that you mentioned, whether some of the allegations that contained on in Taylor and Jaguar Land Rover might be useful either as discussion or as examples of things which would still not be permitted after the judgment in Forstater. Robin, I don't know if you'd like to comment on that, having appeared in Taylor and Jaguar Land Rover.
Well, yeah,
You're quite familiar with the allegations.
All 22 of them. I mean, I was for the claimant. Was it 27? I'm now forgetting. 27, I think. Yeah, I think we didn't have that consideration, and the tribunal did find that they amounted to unlawful harassment, and in that case, that effect looked at the effect on the claimant, or the reasonable effect on the claimant. And so certainly some of them, I don't think they were a manifestation of a belief really in, I mean, I don't hold all 27 in my head. I think there was a lot of manifestation and a lot of unpleasantness in the comments being made, particularly that Ms. Taylor found objectionable. And I think there would be some good examples in there of things not to say to a work colleague in the workplace. I think it might show that one or two people had a belief behind them, but I think Taylor was really about manifestation rather than anything else.
So just to give one of the examples that was picked up in the email, the quote, it's allegation 19, it says, on 30th of April 2018, a male colleague said to the claimant, "What do you think of trans versus TERFs? I don't think trans should use female spaces until they have the op." So
I mean, knowing that that's a question directed at somebody who is known to be a trans employee, I think that's so directly personal to that employee who's in the process of transition that I can't see that would ever be held to be an appropriate thing to have said.
let's see. So here's another question that's been raised. Trans issues are often in the news, of course, and recently the one picked up in the question is the point that it was announced yesterday that the New Zealand weightlifter Laurel Hubbard is the first trans athlete to be confirmed for the Tokyo Olympics. How should employers deal with the likelihood that employees want to discuss topical matters like this in the workplace? And it makes me think there's also, I think it was also yesterday, there was a lot of discussion of the Royal Academy no longer carrying products from a textile artist because of views that she was said to have expressed that were said to be transphobic. So that does seem, that's important. I mean, people do want to discuss topical issues. They'll talk about the news, they'll talk about sport in the workplace. So under what circumstances do you think that could give rise to harassment of a trans person, for instance, or indeed harassment of anyone in relation to trans issues?
I mean, I think I come back to what I just said about Taylor. I think if the issue were, if you're discussing it directly with somebody, let's say that you've got a fellow employee who is a trans sports person, for example, then it might be very difficult to have that discussion in the workplace without being seen to be attacking the individual concerned. Or if you had someone who had the opposite view and had the view that Laurel Hubbard shouldn't have been there, and what you deliberately did was to taunt that employee by expressing pleasure that Laurel Hubbard was competing. Great, you know, that if an employee knew that someone had the opposite view and were using that in a way, I mean, that plainly is creating a hostile atmosphere for the individual. So I think some of Vicky's remarks about context and were absolutely on the button, because if what it is a discussion, I mean, there is the International Olympic Committee, for example, are struggling with this issue. They have issued particular guidance about who can compete at the moment, and always said they would renew that. They would review it after Tokyo, and of course that's been put. Tokyo is now late, so the review is going to be probably a couple of years late. But the IOC themselves recognise that there's a conflict, perhaps, between fairness and participation, which we have to find a way as a society to resolve appropriately. And Vicky's right that if we cut off discussion about controversial matters, then we'll never get to a properly societally agreed position. But that doesn't mean that if it's known that something affects someone very personally, say the employee then turned around and said, I have a relative who's in exactly that circumstance, and I find this discussion triggering and difficult in either direction, and the other employee were then to continue with the discussion in that circumstance, then that would be very different, wouldn't it, than the first remark made innocently and appropriately.
Mm. And isn't that the role of sort of training, workplace training, is to encourage people to think about how well they know their audience, right, before they start to venture into discussions with colleagues that, you know, might reasonably be expected to be potentially difficult or controversial.
Yeah, I mean, how many films have we watched from 20 years ago when we were talking about people who perhaps were in a same-sex relationship, and it's treated as a laugh in a film for somebody to make a comment about partner or wife or husband. And we now know that that's not an appropriate way to launch into a discussion, because, you know, we offer people respect in that way. We learned that there are respectful ways to have conversations.
Mm.
So a related question here that's about the employer posting material. So the question is, might it amount to harassment or indeed constructive dismissal if it's the employer rather than the employee who's persistently posting, retweeting, for instance, gender critical messaging on their personal social media, the content of which makes the employee feel that their workplace is hostile to trans people? So I mean, so well, a first stab at that is, if it's the more senior the person, so the status of the person who's posting or expressing views is really important in the extent to which it's going to have an impact on people. So for instance, in the Page case, the Court of Appeal case Page against the NHS Development Authority, that was also a case where somebody who was a non-executive director of this NHS trust had expressed views publicly, in this case about homosexuality and same-sex parenthood, and his appointment with the NHS trust was terminated. It was really important in that case that he had not just this very senior position, but also quite a high public profile. He'd been very actively involved in the Development Authority. So in the question, when we're talking about the employer themselves who's posting, albeit maybe in a personal capacity, that's immediately going to tie those posts very closely to the employment, and certainly, depending on the exact content, I would have thought that could make the employment a hostile context for a trans person. What's your view, Moira? Robin, Moira?
I think I'm not much more to say. I think you've the seniority point is the cardinal one. Beyond that, it's very context specific. No, that's not a helpful, in a sense, that's not a helpful answer, but it is, because I mean, one view about the case is that I've heard a lot of comment about the case that says, gender critical view.
Oh, I think we have lost Robin. I hope that Robin rejoins us. I think it's worth picking up on a couple of the other factors from the Page case, because I think it's, I mean, the important point is that given the judgment in Forstater, we're always going to end up looking at justification, and particularly I'm particularly interested in the question of the social media posts. But so we talked about the status of the employee. The nature of the workplace is another one of those points that's going to be really important. So, for instance, when you think about key cases like Liddell and homosexuality, that was Islington Council. That was a public body covered by the Public Sector Equality Duty. So that makes a difference. In Negoli, you're talking about a university and membership of a profession. The nature of the business makes a big difference. So whether you're looking at a commercial business supplying services to customers or selling goods, as against an organisation that provides a service to vulnerable people, particularly if the people who might be using the service are likely to have little choice about where they get that service. So again, in the Goli case, it was relevant that service users don't get to choose the social worker they're assigned. And of course, the manner of expression of the views is another factor that's going to be critical. Yeah.
Hi, Katya, I'm back.
Hi.
You don't get rid of me that easily.
Sorry, we lost you.
No, that's all right. What I was saying is that one of the comments I've seen on the case overall is gender critical views are now protected. Well, of course, we knew in some senses they were already because we had the Forstater case, but all the cases are specific. So gender criticality involves a range of views from people who say, on one extreme, you know, trans people there should be reform of the Gender Recognition Act, for example, and the trans people should not have the rights that they do, and that they should be, I don't know, banished to the North Pole, whatever. And at the other end of the extreme, you have people, perhaps like Ms. Higgs, who says, I have my views, but I won't bring them to the workplace. And so understanding the particular view, so it is not, there isn't a blanket takeaway from this case that critical views, like religious views, are not protected per se. It depends on what the view is. And it can be quite, look at the fact that the Taylor judgment did one thing and the Choudhury judgment did something else about where that boundary is of protection. And so it's going to be quite specific about a particular individual as to what their views are. And in the same way that we were talking about what the views might, how a view might be expressed in the workplace by an employer, context is going to be really quite important.
Yes, and I think obviously in the case of gender critical views, one very important thing is particularly in relation to manifestation, whether somebody makes it clear or it becomes clear that they are going to be willing to misgender people. It's in the case against the DWP. I can't remember the exact name, but no, the one about the records from social security records and stuff. So, and yes. Lady Hale, there's a long discussion of the challenges that trans people face, and in particular, and the recognition of the importance of being able to live in the identity that somebody has, and being able to do so peacefully and just get on with your life. In that context, facing the risk of being misgendered is potentially serious, even though, unlike most of the other cases, like the expression of views on homosexuality, where you can look at the sort of intemperate nature of the language, you can look at whether sort of extreme language is used. This is a case where the language, we're just talking about pronouns. So on the face of it, they look mild, but I think Lady Hale's, the passage where she talks about the importance of gender identity, explains why misgendering is potentially harassing or could be discriminatory, even though it's not using intemperate or extreme language. And it's also, I think, underlines the fact that it's not necessarily or primarily about offence either. It's whether something is offensive or not isn't the only relevant question. When we're talking about harassment, we're talking about dignity, whether something's degrading, whether it creates a humiliating environment. And I think it probably would help if we focused on some of those other aspects of harassment more, perhaps, than the offensiveness one.
Yeah,
I think that can be a distraction.
Misgendering is definitely degrading, because if you say, this is my identity, and indeed I have a right to manifest my identity in society, and we've protected that, and yet someone else won't respect that in a location I have to come to. If it's a workplace, there isn't an option. The employee comes into the workplace, or if it's a service delivery location, the person concerned, the applicants that Dr. Wickremeratne was dealing with were referred to him, had to go and see him to have their benefits. They had no choice. And were they to be misgendered or dead named by him in that circumstance, they don't have a choice. They can't turn around and say, no, thank you very much, I'll go and see another doctor, please.
I think there's time for one more. There's time for one more question. Let's see, we've got a lot of questions to look at here.
Katya, there's one on,
yes.
I wonder if it might be a quick one. There's one on whether if you put on your Twitter bio that your views are entirely your own and don't reflect those of your employer, whether that sort of impacts the potential liability for an employer. I don't know what your views are, but I sort of think that's not, it's not unhelpful to make that statement, but it's not a complete get out of jail free card.
I've done a case for a London local authority where somebody had put exactly that statement up and then said all people of a particular race should be put back on the boat next week, and it certainly didn't save that person from the tribunal wrath, if I can put it.
No.
There's one that I think it's quite interesting. I'm particularly interested in the education context. So the question is, in an education establishment, how far does academic freedom come into play when considering an employee's beliefs and whether or not they're protected and whether their expression of those beliefs may amount to harassment? So I think the context we're thinking about here is, let's say in universities, there are obviously many academics who hold gender critical beliefs. Is academic freedom relevant in the question of how they express those beliefs and whether it could amount to harassment? So my view is it can be, but you have to think about the purpose of academic freedom. So it won't be relevant in every context. The purpose of academic freedom is to pursue scholarship, the pursuit of knowledge, to enable teaching and exploration of ideas. So that suggests it's relevant when you're talking about how people carry out the research and how they plan and carry out teaching. But it's not, for instance, going to be relevant when you're talking about how someone interacts in a university committee or how they refer to colleagues when they meet them in the coffee room. Academic freedom doesn't govern those interactions. Those are sort of private workplace interactions.
Or how they take questions from students at the end of a lecture, for example.
Well, I think there it depends on the purpose of the session. So, I mean, there could be sessions where gender critical beliefs are being examined in the same way that in history, you're going to examine Nazi beliefs, or you're going to look at the rights and wrongs of vegetarianism, or you're going to look at the range of views on homosexuality within Christianity. So there will be reference to and description of beliefs which people will find distressing. And my view is that that is part of teaching and lecturing, particularly in a university, the sort of when you're talking about adults who've chosen to study a course. If it's relevant to the course, and so it's something that people can expect to be tackling, then yeah, absolutely. I don't think lecturers are precluded from expressing what their own beliefs are in relation to a topic that's being taught. But actually those situations, again, it's tied to the purpose of academic freedom. It's not going to be, it's not going to protect the expression of those views in, an engineering class where it's completely irrelevant to the topics being taught. So that's my view on the relevance of academic freedom. Right, it is 5:30. I don't want us to run over. I think that this is being recorded, and I hope we'll be able to make it available afterwards. We will double check that. I think you'll also, another plug, be getting information about subscribing to Bloomsbury Discrimination in your follow-up email. But I just want to thank Vicky and Robin and all of you for your questions. And I'm sorry we haven't had a chance to get to more of them. But I hope that's been a useful and rapid overview of the case. Thanks very much.